Welcome to U.S. Immigration TV. Now, I know one of the biggest fears of non-citizens is being ordered deported. Well, were you ever ordered deported or removed in absentia, meaning in your absence, either because you did not attend an immigration court hearing because you did not show up or you were unaware of the hearing, and then the judge just went ahead and ordered you deported or removed in your absence? For example, many years ago, people would apply for political asylum. The asylum was denied. They were put in deportation or removal, but they did not show up. And then the judge just went ahead and ordered them deported. Well, there could be good news for certain people with deportation or removal orders. The Ninth Circuit Court of Appeals, which is one level below the U.S. Supreme Court, recently ruled that there could be hope for people whose hearing notices were defective. As they said, quote, non-citizens must receive a notice to appear in a single document specifying the time and date of the non-citizen's removal proceedings. Otherwise, any in absentia removal order directed at the non-citizen is subject to rescission. Now, this ruling is important because in the past, the government would issue notices to appear, or NTAs, placing a person in removal or deportation proceedings based on, specified immigration violations, such as being out of status, their case was denied, they had fraud. But the NTA did not include the date and time of the hearing. Instead, the NTA would indicate to be determined, or TBD, in that space where the date and time of the hearing was supposed to be put in. Well, the government or the immigration court would later send a second notice that would include the time and the date of the hearing. However, for whatever reason, the non-citizen did not show up for the hearing, but the immigration judge just went ahead, conducted the hearing, and ordered the non-citizen deported or removed in their absence or in absentia. Well, the Ninth Circuit ruled that the original or first NTA must include the time and date of the hearing, otherwise it's defective. And I quote, "The government must provide all statutorily required information in a single notice to appear for all removal proceedings that require notice." So therefore, a subsequent or later notice specifying the date and time of the hearing could not cure or correct the original defective NTA. All right, let's talk about the facts of that Ninth Circuit case. There, the government did not provide the non-citizen with a statutorily compliant notice before his removal proceeding, in that the original NTA did not include the date and the time of the hearing. Instead, the immigration court later sent several hearing notices to the non-citizen's listed address, which happened to be his friend's house. But for whatever reason, the friend never bothered to forward those hearing notices to the non-citizen. The hearing went forward and he was ordered deported or removed in his absence. However, because the original NTA was defective, because it didn't have the date and time of the hearing, the non-citizen was able to go back to court and rescind or cancel his deportation order. Now, if this situation applies to you, where your original NTA did not specify the time and date of hearing, and you were later ordered deported or removed in your absence, you should consult with an attorney about your options, which could include rescinding or canceling your removal order. However, it's very important that if you are going to seek rescission of your removal order, you also have in hand some other form of relief or way to get a green card, such as you're now married to a citizen who can petition you, or you have some other petition with a current prior date. Otherwise, just think about it. If you get the old deportation order rescinded, but you don't have a new way to get a green card, you could be placed right back in deportation or removal, and this time with a proper notice. But this is still great news, and it is a very favorable development for so many people out there who may have a petition or application that was denied, and then they were placed in deportation and ordered removed or deported based on a defective NTA. Now at least there could be a way to get that deportation or removal order canceled or rescinded. I hope you found this video informative. I will continue posting more videos on my YouTube channel, which I hope you find both informative, instructive on immigration news, developments, and some tips and other information which could help you or somebody you know on your immigration matter. Therefore, please like, share, and subscribe to this channel. I'm Michael Gurfinkel, and thank you for watching and subscribing to my channel.